Welcome to this presentation. Today we're going to talk about Chapter 24 of our textbook, and this chapter covers very briefly employment and discrimination law. It's kind of a quirky way of describing this area of the law. It doesn't roll off the tongue, and so I apologize for that stumble. Let's first of all look at where we are in our course, and we're in this module, Chapter 24. As you can see, we are having several other assignments. Some videos to see about disability, agency, sexual harassment, those topics. Be sure to be, of course, keeping up to speed with all of those materials. And we're also, of course, in the textbook, we have a variety of materials to talk about. One thing I want to bring your attention to is there's one spot in the textbook that isn't quite right. I'm going to go to page 523. You probably saw it when you read the chapter, but I want to bring it to your attention in the event that you didn't. On page 523, in this section right here, they talk about DOMA, the Defense of Marriage Act, and it says Section 2 of DOMA remains in effect. This means that individual states may decide whether to permit same-sex marriage in their state. Of course, this is not correct. That is according to the Obergefell decision, which is available to you right here. That particular legal standard changed, I guess, after this edition of the textbook was published. If you have curiosity about the Obergefell decision, you can hear an opinion announcements about 8 minutes long from the decision right here, or you can actually read kind of a summary about the decision right here if you have that interesting. But the takeaway is that I'm sure when the textbook was initially published, this was accurate, but this particular paragraph is no longer accurate. And in fact, in all states, same-sex marriage is permitted, and same-sex marriages that occurred in other states have to be given full faith and credit in states that well, in all states from that perspective. So I wanted to flag that issue, an example of the textbook not being completely up to date. So let's go ahead and get started with the substance of our chapter. So I'm going to go into our slideshow at this point. Labor and employment law was the area of practice that I had for 20 years, so this is near and dear to my heart. I'm probably going to go a little bit overboard. I apologize in advance by giving you more information than perhaps you wanted to have. I'm going to give you a little bit my spiel, though, before we begin about why this subject can be so meaningful. Labor and employment law is about the human experience. We all, just by being adults, are at times involved in the labor market. We usually have had bosses. We've usually had coworkers. We've interacted with customers. Sometimes we've supervised others. We've had many of those roles, and if you haven't had one of those particular roles yet, you probably will in the not too distant future. And the interesting thing about labor and employment is that people are interesting. People do the darndest things. People do things that you would never in a million years expect people to do, and they do it on a very routine basis. And as a result of the quirks and the idiosyncrasies and the sometimes meanness of human beings, we have these cases of people acting inappropriately and how the system is going to address or even to define what appropriate behavior might look like. So it really is about the human experience. We also see, of course, the human experience in the areas of criminal law and tort law, and really, in some sense, in all areas of law. But I think that there's probably no other area of the law in which we see the human condition with all of its foibles quite to the extent that we'll see it here. Because we're not talking, for the most part, about bad people or criminal people. And we're not talking about people who intended, in most cases, to do bad. We're talking about the rub of one person against another, metaphorically speaking, usually, sometimes not, and how that can create opportunities and problems and concerns along the way. So hopefully you'll see in this presentation a little slice of the human condition and how it impacts the work world. I said in another lecture, the business organizations lecture, that there are really 2 chapters that we cover in this course that are extremely practical and can have direct applicability in your lives, like immediately. One is the business organizations chapter, and that's especially practical if you are of an entrepreneurial persuasion. But the chapter 24 is practical for everybody. You're either going to work for somebody or you're going to start your own business, and you hope to eventually employ other people. That's almost always going to be the case. It's hard to imagine somebody who doesn't have that experience. And so these laws are going to affect you, impact you, in some sense, every single day of your employment or of your management of others. So that's one way that this chapter is very practical, but there's another way. You know, most of the areas of law that we've talked about at this point have been pretty intuitive. My guess is, as we were covering material, you probably thought to yourself, yeah, that's about what I would have come up with, or that's what I would have guessed the rule was, or I had some inkling it was something like that, and you've really just confirmed what I already suspected. I mean, and that's a good thing. We kind of expect the fact that we had kind of a sense about what the law is, and that sense has been confirmed. It probably indicates that we have, you know, kind of a good judgment, a good understanding of the culture, and that the law is reflecting that those values. So that's a good and not a surprising development. When we get to this chapter, in my experience, most students don't have that radar that matches up with what the law actually provides, at least in some important areas. Not all areas, but many areas. This area of the law is not as intuitive for most students as other areas are. And so as we cover this material, I think you're going to have more moments of, really? Or, gosh, I wouldn't have thought that was the case. Or, I need to talk to my congressman or my governor about that. When you have those moments, certainly I encourage you to use whatever political tool that you think is helpful and appropriate. But what I'm concerned about you getting is an understanding of the way the law is today, because whether or not you agree with the law, it is the law, and it's what we need to deal with in our working environment right now. And so whenever you have a misunderstanding or misinterpretation of the law that may cause you to act in ways that are not helpful for your circumstance, or not helpful for your subordinates, or not helpful for your organization, your employer. And so in that sense, the lessons here will be very, very practical, in part because the information I'm going to share is going to be a little bit surprising. And hopefully it'll be fun. So let's get started. I like to think about employment law as being a little bit upside down, because in this area of the law, we're going to look at it from the perspective of the employee sometimes, because after all, most of us are employees for most, if not all, of our working lives. But then we're also going to look at it from the perspective of the employer. Once you start managing people, then you are actually wearing 2 hats. You're still an employee of your employer, but now you have the role of employer because you're manager. The decisions that you make, you're making on behalf of the employer. Imagine for a second that you hire Bob. You think he's going to be a great employee. He's got a great resume. He was a wonderful interview. He had awesome references. He seemed to have exactly the skills and experience that you needed for the particular job opening that you had. Well, he arrives, and you can just tell from day one it's not going to work out. He doesn't get along with others. His work ethic seems to be poor. He doesn't seem to have the knowledge or the skills that you thought that he had, and it's just not working out. You keep on hoping that it'll improve. You talk to him, you counsel him, you give him some training, you take all the steps that HR is recommending that you take, but after 2 or 3 or 4 weeks, you realize this is just not going to work out. And so you make the difficult decision to end Bob's employment. When you decide to end Bob's employment, you are acting as the employer. You are acting as the corporation, assuming we'll say for a second that you are your employer and Bob's employer is the corporation. And so you are being the hands and the feet, excuse me, of that corporation when you make the decision and you communicate the decision to Bob. Okay, so a few weeks later, your boss calls you in and he says to you, look, we've had some economic reversals in our organization, and as a result of those reversals, we have to let some folks go. And unfortunately, you're one of those people that we're just not going to be able to keep employed at this time. We regret the need to make this decision. We wish you every success. This will be your last day of employment. So at this moment, you are now the employee, and you may be thinking, you can't do that to me. That's not right. That's not fair. You're going to let Larry stay, or you're going to let Teresa stay, but they're much less useful. They're much less hardworking than I am. And so you might think to yourself, what are my rights as an employee? So the takeaway is that you may have both of these roles, even in the same day, even in the same hour as you are working through your career. And so it's important to know from both lenses what your responsibilities are when you're the employer, what your responsibilities are when you're the employee, what your rights are when you're acting as the employer, and what your rights are when you're acting as an employee. And just be prepared for things to sometimes seem upside down, surprising, not at all what you would have expected. Let's first of all talk about employment at will. This is a concept that is the foundation of employment in the United States. Every single state, with the possible exception of Montana, has the at-will employment rule. And while Montanans will say they don't, they really pretty much do. It's a very, very subtle difference from employment at will. So the bottom line is that the default setting in our legal system in the United States is employment at will. There are some exceptions. For example, there are people who have a written employment contract. Those are few and far between. In the United States, people who have written employment contracts are typically going to be school teachers and very senior executives in companies. So again, that's not likely to be your particular circumstance until you're well into your career. The other category of folks who have written employment contracts are people who work in a unionized environment. They have a collective bargaining agreement. Well, people who are in unions or in collective bargaining situations certainly can have union contracts, but those are relatively rare in this market. They're more common in the northern part of the country. And most unionized jobs are not jobs that require a college degree. So most likely you will be seeking employment at least, as your career progresses. Maybe initially you might be in a collective bargaining agreement, but as your career progresses, it's likely that you will see yourself in a more managerial role. And so as a result, most of your career you are likely to be employed at will. That's what the standard is likely to be. So what does that mean to you? Well, it means, this is the good news, that you can quit at any time. You can quit, let's say I'm the cashier at Target, and I have just had a customer who was rude and unpleasant to me, and you know what, I've just had a really bad day, and it's been one awful thing after another. I finish checking out that customer, I close my cash register, I walk into the manager's office, I give him my ID or whatever the credentials are, and I say, I'm out of here. I'm quitting. I'm allowed to do that. I have not breached my contract with Target to do so. I can quit at any time for any reason or no reason at all. Let's imagine this scenario. Let's say that I'm still a cashier at Target, and I am required to train somebody who is of a different ethnicity than myself. I happen to be a bigot. I don't like people who aren't of my race, and I don't really want to deal with them. And but my manager says, no, your job is to train Bob here, and you need to do a good job doing it, and you need to do it in a respectful way to Bob. And I say, you know what? I don't like people of Bob's ethnicity or race, and so I refuse to train Bob, and I'm quitting. Am I a nice person? No. Am I a decent person? No. But I'm allowed to quit for any reason, no reason at all, offensive reason, whatever reason I want. I'm also not required to give any notice. Obviously, it's very inconvenient for Target if I quit with no notice. Who's going to man that cash register? Who's going to take over that shift? It may well be that the customers are inconvenienced for a time. Maybe some of those customers get so frustrated that they swear never to come back to the Target. Maybe there'll be other employees who are going to be required to work extra shifts that may cost Target more money and overtime. It may inconvenience those particular employees. It may even be that a manager is required to take on those responsibilities. I have significantly inconvenienced a lot of people because of my probably somewhat immature behavior, but I'm allowed to do that, and Target can't sue me about it. Now, do I as a your advisor, maybe your instructor, do I recommend you doing that? No, because while Target doesn't have any legal recourse against you, Target can certainly give you a bad reference. They can tell future employers, well, you know, Groover quit without any notice, or Groover quit because she refused to train somebody of a different ethnicity than her own. And so, because those are all truthful statements, I wouldn't be able to complain about that. And you can see how that could negatively impact my ability to find another job. So while I have the legal ability to do those things, it's probably not a very smart plan. In fact, I recommend that you give at least 2 weeks notice whenever you leave employment, unless there's really pretty extreme circumstances. And as you go up the career ladder, I encourage you to even give more notice. When I left JCPenney, my employer before Colin, I gave, I think, probably about 3 months notice. 2.5 months, I can't remember exactly, but I gave as much notice as I could, and 4 weeks I would consider it at when you reach a pretty significant level, is a reasonable time frame to give. So giving more notice is better than giving not enough notice. So that's the good news. You can leave at any time. You are employed at will, at your will in that situation. But unfortunately, there's a flip side to this, and this is the part that gets more publicity. And that is that an employer may fire an employee at any time without any notice for almost any reason. The only limitation is that the reason cannot be unlawful. Let's imagine that I'm still working at the Target. I'm a cashier, and it happens that the store manager is calling a meeting and everybody is assembled into the break room. We'll say at that particular shift there's 50 employees in the break room. And the store manager comes to the front of that break room and he goes, who in this room is wearing anything with a little bit of green on it? People are like, that's kind of a strange question. And so people kind of look at their clothes, and of the 50 people, there are about 10 people have something in their clothes with a little bit of green. And so those 10 people raise their hand. The store manager says, okay, come to the front of the room. And those 10 people in the front of the room. And really those 10 people reflect a cross-section of the population. There are some old employees, some young employees, employees of all the different races and ethnicities reflected in the population. Some of the people are managers, some of the people are cashiers, some of the people are stockers. It's just a very diverse collection. They don't seem to be united by anything other than the fact that they're wearing a little bit of green. And these people, these particular employees don't wear green every day. They just happen to have worn green that day. In fact, probably every person on staff has something green in their wardrobe that they wear from time to time. So anyway, the 10 people who are wearing green come to the front of the room as the store manager suggested. And in front of the whole room, the store manager says, okay, you 10 people need to clock out. You're fired. They're like, what? Is this a joke? What do you mean we're fired? There's nothing in the dress code that says we can't wear green. If you want me not to wear this, I'll go buy another shirt off the floor and wear that instead. Nope, there's nothing you can do to fix it. I just decided to fire anybody who's wearing green today. Is that a smart management decision for that store manager? Absolutely not. But is it an unlawful decision? No, it's not an unlawful decision. Because it's not unlawful for a store manager to fire people because they wear green. So that's how at-will employment works. Now, do employers routinely or regularly fire people for absurd reasons like that? Well, I hope not, and I don't think that's a tremendously common way. But the point I'm trying to make is that the vast majority of reasons people fired are perfectly all right, legally, even though we might look at it and say, well, that was petty, or gosh, I wouldn't make a decision on that basis. It's pretty rare that they raise a legal concern. It's only when the reason itself is unlawful that we have recourse to the court system. And so the rest of our presentation is really talking about those few carved out reasons that are unlawful. Those are the exceptions. Unlawful is not the same thing as unwise or unfair or unjust. Most unwise, unfair, unjust employment decisions are going to be perfectly lawful. Doesn't make them suddenly fair or just, it just makes them not a violation of the law. Our default setting is we're going to let employees decide who they want to have work for, who they want to work for, and we're going to want to give that same right to employers with just a few limitations. Okay, so let's talk about federalism again. We talked about this in the chapter concerning how the government was set up, and we talked about how the federal government has a certain level of authority and the state government has certain levels of authority. There are certain areas that the state government is the only entity that can act, and then there are other areas where only the federal government can act. Then there are areas where one or the other predominates. For example, most criminal law is run by the state government or is controlled by the state government. Most things like interstate commerce is going to be handled by the federal government. But when there is an area that both the state government and the federal government both have the ability to legislate in, we need to have a pecking order. We need to have a system of deciding, well, who gets to be the tiebreaker? Who gets to decide who wins? And we find the authority for that in the Supremacy Clause in the U.S. Constitution. And it says when Congress has the right to legislate in that area, and again, we always need to find an enumerated power for this case, for this situation. But when there is that authority, it gets to be the tiebreaker. It gets to be the final say in it. But the fact that the federal government has the ability to say, we're preempting, or we're going to, our position is going to, or our law is going to take precedence over that state law, the federal government at the same time can say, we're choosing not to use our authority in that way. We're choosing not to preempt. So again, the federal law can proceed in both ways. And we see both stances in employment law. Employment discrimination law, unlike the vast majority of other areas of the law, is primarily federal law. That's especially true if you exempt the handful of states that have a great amount of additional legislation. You know, if we were in California or Wisconsin or New York State, there's a lot of state regulation of the employment relationship that goes beyond the federal law. But in states like Texas and in most southern and most Midwestern states, we'll find the reverse, that the state legislature has been relatively quiet in this area and that most of the activity has been in the federal area of the law. And so there's much more activity there. It's one of the reasons why when I was a litigator in the employment area, almost all of my cases were in federal court. We talked previously when we were talking about jurisdiction, we talked about how the default setting in our legal system was that we're usually going to be in the state court of general jurisdiction. But that's not true for this area of the law because most of it is a federal law. Federal law raises a federal question. That's one of the ways you get into federal court. And so most of the time we're talking about employment cases, we're talking about federal laws. So how does the Congress decide whether they're going to preempt the states or not? Well, let's talk about the usual rule first, then I'll talk about one important exception. So the usual rule is that the federal law has decided, the Congress has decided to treat federal law as a floor. This is the minimum protection. The federal law is providing a minimum protection to all employees in the United States. But states can put additional protections for employees above that. What a state can't do is provide protections at a lower level, because in that situation then the federal law kicks in, and that of course is what's going to control. Obviously the employee is going to choose the legal protection that is greatest. So basically, under most areas, the Congress has elected to allow states to give more rights, but can't give less rights than federal law. There is one exception to this area, and that is a law that we're not going to really talk about very much, but I want to present it to you so you can see how the alternative would work, and that is the ERISA law. Here we go. This has to do with employee benefits. When Congress is in the process of passing a law, as you can imagine, it's a political process. And so there's inevitably going to be some horse trading. One congressman or congresswoman wants X in the law, another wants Y. Well, maybe they both give a little bit and they end up with X or R or a little bit of Z or whatever, something they can all live with. And so as a result, nobody gets exactly what they want, but everybody gets something, or at least everybody who's ultimately willing to vote in favor of it gets something. Well, that was kind of the story with ERISA. ERISA is a law that gives certain tax benefits to corporations if the corporation will provide certain benefits to employees. But because the federal government is giving up tax revenue as a result, it wants to make sure that the benefits that the employee is getting are benefits that the federal government thinks are beneficial to the culture at large, to the larger society. And so they established rules about how that was going to work. And one of the rules is that states can't require employers to provide more benefits than what ERISA requires. Well, first of all, let me just pause here and say ERISA doesn't require any benefits for employers to provide. It just gives tax advantages for companies who choose to provide those benefits. So let's imagine an ERISA rule. This isn't really a rule, but let's just pretend this were a rule. So this is hypothetical, not at all true. So let's say ERISA said an employer who wants these tax benefits is required to give each employee at least 5 paid days of vacation a year. And let's say company A says, well, we think that's beneficial. We want to be able to get that pay that we give them. We want to be able to take that off as a deduction to our taxes that we are required to pay the federal government. And so we are choosing to give our employees those 5 days off a year. We're not giving them any more because we don't have to take advantage of the ERISA benefits. Well, company A's place of business, we'll say it's in Albuquerque, New Mexico. Well, the New Mexican legislature decides to require that all employers provide at least 10 days of paid vacation a year. Well, this company A says, wait a second, we're complying with ERISA, and ERISA says we just have to give 5. So we think that this particular area of the law is preempted and that the New Mexican legislature doesn't have the power to require us to give 10 days because we happen to have an ERISA plan that complies with federal law that requires only 5 days. Well, the answer for that company is that yes, they are correct, because the compromise reached by the Congress was that any rule that ERISA has is not just a floor, but is also a ceiling. that states can't require employers to provide more generous benefits. So if a particular benefit qualifies for ERISA, and then the legislature in that particular state starts requiring a more generous benefit vis-a-vis employees, then that particular employer can say, wait a second, we don't have to comply with that rule because we are an ERISA plan. But again, ERISA is an exception to that general rule. Usually states are allowed to provide more benefits to employees. Let me give you an example of that usual rule. Imagine, or this doesn't to take any imagination, we are in New York State. In New York State, sexual orientation discrimination is a prohibited class of discrimination. So let's say that I have a store in New York. We'll say Albany, New York. And Bob walks in, and Bob is interviewing for the job. He's got all the qualifications. He's an impressive candidate. At the end of the interview, we're shaking hands, and he goes, his phone rings, and he looks down, he goes, oh, it's my husband calling. I'll call him back later. Anyway, thank you for your time. Well, at that moment, the hiring manager had planned on offering Bob a job, but now that this hiring manager knows that Bob is a husband, the hiring manager knows that Bob is a gay man. And this hiring manager does not want to hire a gay man for this position. He wants to discriminate against Bob because of his sexual orientation. Well, federal law does not make sexual orientation a protected characteristic. It's perfectly lawful under federal law to refuse to hire somebody because of their sexual orientation. I'm not here to say that's a good policy or a bad policy. I'm just telling you what the policy is. That's what the law is under federal law. And so that manager, if he were to decide not to hire Bob because of Bob's sexual orientation, he is not discriminating against Bob and not doing unlawful discrimination against Bob under federal law. But guess what? New York state law prohibits sexual orientation discrimination in employment. So that manager has violated state law, but not federal law. And because the Congress chose not to have preemption with respect to employment discrimination laws, that New York law is in effect and does apply to those circumstances. We're going to talk about three kind of buckets of law. One bucket is employment discrimination law. This is probably, I'm going to say this is 85% of the legal activity that we see in Texas. Then I would say this next area, which is oftentimes called individual employee rights, I'm going to describe it as 10%. And then we have labor law, which is anywhere from 0 to 5%. So, maybe this is a little bit more than 85, maybe this is a little bit more than 10. As you can see, this is wildly more important in this part of the country. It is true in all parts of the country. This is by far the most important characteristic. Really, the only one that varies is this one, the importance of labor union activity. Here, it's not very important. There are a few states that it is more important, but it never really competes with importance with employment discrimination law. Although there are certain industries where it might compete, but just generally over a geographic area, there's not even a place that's going to compete. So if you are focusing your attention on, what is the area of the law that I'm most likely to interact with, be exposed to, be responsible for knowing, by far this is the one you're going to want to spend the most time on. But these others are also important areas of the law, and so we'll cover all three of these. But we're first of all going to talk about the most important, employment discrimination law. There are three important statutes in this area. You are not expected to know the year that the laws were passed, so don't worry about knowing this year. We'll have Title VII, the Civil Rights Act. We'll have the Americans with Disabilities Act, and we'll have the Age Discrimination and Employment Act. Each one of these names have nicknames or abbreviations because, as you can tell, the names are kind of a mouthful. So Title VII, the Civil Rights Act, is usually called Title VII. And it's usually not written with a 7 like this. It's usually written with Roman numerals. Americans with Disabilities Act is usually called the ADA. The Age Discrimination Employment Act has an E in here, right? And so it's usually called the ADEA or ADEA. The way that I remember to keep ADEA straight from the ADA is that age has an E in it, but disability doesn't have an E in it. Now, if you write disabilities, you have an E in it, but the word disability doesn't have an E in it. So that's just my little trick for remembering which one is which. Okay, so we have these 3 laws, and each one of these laws provides a certain type of protection, or sometimes multiple types of protection, for employees based upon some characteristic that they possess. If a particular law protects that employee because of that characteristic, he or she is going to have a pretty broad range of protections. He or she is going to be protected from discrimination in the hiring process, in the firing process, or with respect to anything relating to the terms and conditions of employment. And this would include segregating employees based upon that characteristic. We can't have anything like separate but equal, the kind of Plessy v. Ferguson idea that was held to be unconstitutional in Brown versus Board of Education in 1954. So basically, once you have a characteristic that falls into these categories, you're protected pretty much in every single respect that relates to your employment. So we're going to go through the different types of protections that we have. Well, see, most of these are actually covered by Title VII, because you can see in the name Americans with Disabilities Act, it's pretty easy to figure out what the protection is. It's about, disabilities, right? Not a hard one. And you can tell Age Discrimination Employment Act, I don't know, I'm guessing age has something to do with this. So when you're not considering disabilities and you're not considering age, if it's a protected category, it's probably going to be in Title VII. I put in brackets what the particular statute is, but it's pretty intuitive, so don't feel like you have to commit this list to memory. Just kind of remember the Title VII is the catch-all one. So the first category is race and color discrimination. Now, these sound like they're the same thing, right? After all, a pretty significant factor in the way that humans distinguish between races is the amount of pigmentation that a person has. And so sometimes they can be synonyms for each other, but they also have some legal distinction between the two. For example, imagine that I am a darker-skinned African-American employee. My supervisor is a lighter-skinned African-American. Obviously, we're members of the same race. We both acknowledge that we're members of the same race. And in our workforce, I have coworkers of all kinds of different races. Some are white, some are Hispanic, some are Asian, some are African-American. But it just so happens that I am the darkest skin of that population. And it seems that the lighter the skin tone that the person has, the better that supervisor treats him or her. Now, I'm not likely to be successful in alleging race discrimination, although I certainly can do that, because the supervisors are going to say, wait a second, I'm African-American. I'm proudly African-American. I don't know what you're talking about. I'm not going to discriminate against someone based upon my own race. But it may not be race discrimination. It may be color discrimination. It could even be the case that my supervisor might treat people of his or her race in a less advantageous way based upon a difference within that racial category, and might treat people of other races not in a discriminatory way. It's pretty common when people allege race discrimination for them to also allege color discrimination and vice versa. But I would say probably every color discrimination charge I've ever seen also includes a race claim. And most race claims I've seen have also included a color discrimination claim. Usually the clever strategy for a charging party or a potential plaintiff is to allege as many theories as you think you might be able to prove. At the beginning of a case, you're not sure what you'll be able to prove and what you won't, so this is kind of a good starting point. Let's go on to the next category, which is religion. Religion, well, let me pause here before I go on and talk about, so I'm just going to check off race and color. So I'm going to talk about the big toe in the water. When I was in law school, I took 2 courses, well, actually 3 courses in employment and labor law. And I practiced in the area 20 years. And so to distill these topics into 20 pages or a few hours of lecture, kind of by definition is silly, because it would be a little bit like Stephen Hawking trying to explain the universe in 3 hours. You can really just start touching on the subject just a little bit. You're not going to do a very deep dive. And sometimes when you talk about a subject in a very, very high overview way, it can create some miscommunications. It can make the people hearing it think, oh yeah, I got that. I understand everything that the instructor said, so I really pretty much understand this topic. That isn't going to be the way that I'm able to present here. I'm going to be able to talk about some really generalized concepts, but I'm not going to be able to drill very deeply at all. So what I hope that you'll leave this presentation with is an understanding of when you need to go speak to somebody else. But please don't think that my intention here today was to give you enough information so that you would understand the law sufficiently to make difficult calls, because I haven't even begun to approach that level of analysis. Really here what I'm trying to do is empower you to be able to realize, oh, wait a second, there's some protection here for people against race discrimination. Okay, well, I'm concerned that this situation might be moving in that way. I need to talk to somebody in HR, or I need to talk to somebody in the legal department. Please don't leave this presentation thinking, okay, I know all there is to know about this particular topic, so I can make an informed and wise decision. That's just, again, beyond the scope of this course. So let me go back to religion. Religion is different than race or color discrimination in lots of different ways. One way that it's different is that race and color are pretty much immutable characteristics. I can't change my race. I guess I can stay out of the sun or go into the sun and slightly change my color, but for the most part, I am what I am. It's a genetic thing, and that's not going to change. But with religion, I mean, it can change. I can be a Methodist today and a Muslim tomorrow and a Hindu the next day. And then the day after that, I can become an atheist. So that is a mutable characteristic, which is different than the other things that we'll be talking about. Another thing about religion is that it's not something you can look at somebody and necessarily ascertain. I mean, we might reach some conclusions. For example, when we see people who appear to have European ancestry, most of the time we're going to think, well, that person's probably culturally Christian or culturally Jewish. They're probably not a Buddhist. They're probably not a Hindu. They're probably not a Muslim. But there are parts of Europe that do have Muslim pockets, and there certainly are people of European ancestry who have converted to other religions. But still, there is some kind of historical tracking along the lines of religion. So there's, I guess, a little bit of predictability there. So that's one difference between race and color compared to religion. You can't see it, and it can change. Another difference is that a religion is an intellectual idea. It's about certain beliefs or paradigms, worldviews that person has. My race doesn't tell you anything about how I view the world, or what my assumptions are about the world. Um, it's just a story about my ancestry, who my parents were biologically. But religion does start informing some of my views about the world. If I happen to subscribe to this religion, it lets you know how I view certain aspects of the world. And so it's an intellectual endeavor, not strictly a genetic issue. So that's another difference between religion and race and gender. Another difference between religion and race and gender is how the law approaches this topic. And this has to do primarily with the fact that it is an intellectual undertaking. Title VII requires that employers not discriminate against people based upon their race or color or religion in terms of hiring and firing, in terms of conditions of employment. But it puts an additional obligation on the religious observance, and we call this reasonable accommodation. Employers are required to reasonably accommodate the religions of their employees. So let me give you some common examples of that. One example would be if I wanted to dress a certain way or groom myself in a certain way or wear certain types of indicia of my religion, my employer would have to decide, so to make this reasonably accommodate, here we go, how to proceed. So let me give an example. Let's say that I am my ancestors are from a community that, well, I'll pick a ridiculous one, so just for the sake of having an example. Let's say that I'm Scandinavian, and because of my ethnicity, I want to wear a Viking helmet to work every day because I'm proud to be Scandinavian. Well, the dress code in my place of employment is no headgear, at work. And so I am wearing this fairly kind of ridiculous hat. It's a distraction. People are constantly wondering what's going on. Why is she wearing that on her head? It doesn't really fit in with the culture. So an employer would be perfectly within its rights to say, Gruber, take off your hat. And if I say, nope, I refuse to, it's part of my culture, they would be completely within their rights to say, we don't need your services anymore, again, because of employment at will. But let's make it different. Let's say that because of my, I'll give you some real cases. There was a gentleman who was of the Sikh religion. One of the aspects of the Sikh religion is that men and women do not cut their hair. And as a result, an adult person in this religion is going to have a lot of, if it's a man, a lot of facial hair and also hair on the top of his head. As a result, men typically wear their hair in a turban for kind of safety reasons, because there's all this hair, it could get caught in things and things along those lines. It's a way to keep things fairly neat and orderly. And so the turban is definitely associated with people of this particular religion, although I'm sure there are other people who wear turbans as well. Anyway, there was this gentleman who wanted to work in New York City in the subway system. And the subway subway, I guess, government entity told this gentleman that he would not be able to work there because his turban was because there were no hard hats that would be able to include his turban in it, and so he would not be able to wear a hard hat. And the particular job that he wanted to do would require wearing a hard hat. It would actually be down in the tunnels doing some maintenance work. Well, the man responded by saying, well, look, okay, I get it. I get that my turban is not consistent with wearing a hard hat. And I get that there's some danger, not a lot, but some danger that there could be some incident where I could get hit in the head by something in the tunnels, and that could be bad for me because I'm not wearing a hard hat. But I'm willing to take that risk. I'm willing to possibly get injured because of my religion, and so therefore that's really my business, not your business. You ought to allow me to work down there. You ought to reasonably accommodate me by excusing me from the hard hat requirement. Well, the state of New York responded by saying, well, it doesn't quite work that way. These are the reasons why we don't feel like we should have to do that. First of all, if you get injured down there, then you'd be able to file for workers' compensation benefits. And we would have to provide those benefits to you because you were injured at work. And there is no exception for an injury that was related to a religious requirement. So that will cost our department money, and that will cost the taxpayers money. And so it's not true that that your decision affects only you. The second reason that we think that this decision doesn't just reflect you is that, let's imagine that there is some incident and you're hit in the head and you are rendered unconscious. Well, your coworkers would be expected to pull you out of that situation. Let's say there was continued to be danger, and so they would have to carry you or go back and get you at some risk to themselves. And there might be some additional injuries that they sustained trying to rescue you. If you had been wearing your hard hat, you wouldn't have been knocked unconscious. You would have been able to rescue yourself. And so your decision not to wear a hard hat could jeopardize the safety of other people. And so what the court said is, or what the New York subway system said is, that wasn't a reasonable accommodation. And the ultimate decision was that, yes, the New York subway system was correct. It's not reasonable to accommodate something, and usually the rule is that if it involves safety aspects, genuine safety aspects, not safety aspects the employer is making up, but genuine safety aspects, then the employer is not required to accommodate that particular view. And we also see that that type of issue coming up wherein a person feels duty-bound to wear loose-fitting or flowing clothes as part of their religious observance. And the nature of their work is that they are working with machinery where their clothing could get caught in the machinery and they could be injured. And so that would usually not be the subject of reasonable accommodation. Let me give you another example of religious accommodation relating to one's appearance. And that relates to, I think this was a Domino's case. It was a pizza delivery service of some type. Might not have been Domino's. Anyway, Domino's had a dress code that required that male deliverers be clean shaven. The idea behind the rule was that when a pizza is delivered to somebody's home, the person who is accepting the delivery is in a bit of a uncertain situation. There's a stranger at the door. They're expected to open the door. Maybe this is a bad guy. Maybe he's going to rob me or murder me when I open the door. And so Domino's wants to have somebody on the other side be as least intimidating as possible so that the customer feels comfortable, doesn't feel intimidated, is willing to open the door. And so Domino's, apparently having done market research, concluded that a clean-shaven face is more likely to be perceived of in a positive light, and so they required men to be clean-shaven. Well, in some religious traditions, some males see having a beard as perhaps not a requirement, but a good thing. And the two, I guess, that I've heard of this about would be Judaism and Islam. And so some devout Jewish men and devout Muslim men have chosen to have a beard for that reason. Well, some of these men complain, saying, look, I have the beard because of religious reasons. It doesn't interfere with my ability to appropriately deliver pizza. I'm not a better or worse pizza deliverer because I have facial hair. And so in those cases, the courts have usually said, well, there's not really a safety issue here. It's just a customer preference issue. And so therefore, the employers should be required to accommodate that. But let's imagine there was another person. Let's say that this person said, well, in my culture, beards are considered a good thing. And so I culturally want to have a beard to reflect that fact. Maybe this person's ancestors are from, we'll say, a part of Africa where a facial hair is highly valued, but it has nothing to do with the religion of that person. Well, then that person would not be able to assert religion as the reason for his request to have a beard. His claim might be a of race or color, possibly national origin, which we'll talk about in a little bit. Well, that doesn't have a reasonable accommodation requirement. So under those circumstances, Domino's would be perfectly free to say, no, you have to be clean shaven, but Bob, who's a Muslim, doesn't have to be clean shaven. There is a medical condition that can happen for men of any race, but is more prevalent in the African ancestry, men who have African ancestry. And this, it's pronounced something like pseudofolliculitis or something like that. I mean, what happens when people who have this condition experience it is when they shave, because their beard hairs are curly, they can get ingrown hairs, and those can be disfiguring and painful and can leave scars. And so under those circumstances, men who have this condition, once they get their beard hair, so they're not clean shaven, then they don't have to worry about having this condition develop because the hairs won't become ingrown once they've grown out. In that situation, there is no reasonable accommodation action, but it is considered a racial characteristic. And so to discriminate against somebody who has that condition, because it's more prevalent in a particular race or ethnicity, there is a need to accommodate it. But we see with beards that even religious accommodation is not complete. Imagine that our Bob, who's our devout, we'll say he's a devout Jewish person now, he's worked for Domino's for a while. He decides he wants to become a firefighter now. He applies at the fire department. They think he's an awesome candidate. He goes through fire training. He's the top of his class, physically strong, brave, good teamwork, all the characteristics that one would want in a firefighter. It now comes time for him to become an actual firefighter, and his supervisor tells him, Bob, you're amazing and awesome, but of course before you become a firefighter you will need to shave off your beard. Bob says, well, I can't shave off my beard, it's part of my religious observance. Well, the supervisor says, well, if you're a firefighter you need to be able to wear a gas mask so that you can go into fires where there's a lot of smoke and things along those lines, so you can rescue people. If you didn't have your gas mask on, you might pass out and we might have to rescue you. And even if you didn't pass out, you might not be able to rescue other people because you might run out of oxygen and not be able to carry them. And the way that our gas masks are situated is that you can't get a tight seal if you have facial hair. You need to have a smooth face so that there's a good seal on the mask, and so you need to be shaved in order to do that. Well, the case law again is clear that now we're talking about a safety issue, kind of like the Sikh with the turban, the man with the beard has to shave the beard in order to get that good seal, and so therefore it's not reasonable to accommodate that. So I've talked about some religious accommodations that are pretty common, but the most common category for religious accommodations, it has nothing to do with appearance issues or philosophical issues. It has to do with the very practical issue, which is work schedules. Many religions have a certain day for special religious observance. Sometimes that day is called a Sabbath. For people of the Jewish faith, it begins at sundown on Friday and ends at sundown on Saturday. For Jehovah's Witnesses and Seventh-day, I'm not sure about Jehovah's Witnesses, but for Seventh-day Adventists, it's also the Saturday date. For most Christians, it's going to be the Sunday date. For Muslims, it's a lot of times Friday. Other religions can have other holidays. Even apart from the once a week special day, there can be other holidays throughout the year. Christmas, Easter, Yom Kippur, Rosh Hashanah, Ramadan, holidays along those lines, Diwali for Hindus. Holidays like that that may not occur on a particular date or a particular day of the week every time, where the person may have some religious obligations. There might also be religious obligations associated with particular times in one's life. For example, the passing away of a parent can create obligations to perform certain rituals. And so that could be another category of obligation. So what is the employer's obligation in terms of working out the scheduling ideas? Let me give you an example. Imagine that we have we'll say that this is we'll say this is a man who is culturally Jewish, but he's not observant. He isn't a member of any other religion, but this religion isn't his thing. He's not into it. And he goes to work for, we'll say, Kroger. And this particular Kroger is open 24/7. And he is working as a cashier in this Kroger. And he wants to get as many hours as he can, so he tells his supervisor that he has any availability. And in fact, if you work the late shift or you work on Saturdays and Sundays in this particular Kroger, you get additional pay because they're less desirable shifts. And so he actually pretty routinely works on Friday night and Saturday because of the additional pay. Everything is going fine. He's a valued and good worker, a good relationship with coworkers, doesn't have customer complaints. Everything is going great. But then he starts reflecting upon his life and he decides, you know what, I want to become more devout. I want to get more involved in my religious aspects of myself. And so, he stops eating pork and shrimp. He starts praying regularly, and he starts observing the Sabbath. He's going to synagogue at those times, and even when he's not in the synagogue, he now refrains from work. He follows the rules. He doesn't drive a car during those days. He doesn't do other activities that would be inconsistent with his understanding of Judaism. So now he goes to his supervisor, and supervisor says to a supervisor, hey boss, I need time off from about an hour before sunset on Friday all the way through about an hour after sunset on Saturday, because now I'm an observant Jew and I'm not able to work during that time. Well, the supervisor says, well, Bob, you're a valued employee. I'd love to work with you, but right now we are understaffed, and those are some of the very busiest times that we have in the grocery store. And so, I'll try to work with you, but I just don't know if this is going to work out. So the first plan they have is that they're going to allow Bob to switch out schedules with the other cashiers. Typically what happens is that the schedule for the next week is posted Thursday at noon, and it actually goes into effect, we'll say, at 12:01 a.m. on Sunday. So Bob gets the schedule, And of course, he doesn't care about Sunday, Monday, Tuesday, Wednesday, or Thursday. He's focused on the Friday and the Saturday. And he sees that, yes, he was scheduled to work from 6 p.m. on Friday through 2 a.m., I guess, on Saturday morning. And so now he contacts all of his coworkers who aren't also scheduled at that time and says, hey, would you be willing to swap schedules with me? I'll be willing to work your Wednesday schedule or your Sunday schedule or whatever. Anyway, for a few weeks, this actually works out. He's able to find somebody who's willing to take on his schedule. But after about 3 or 4 weeks, suddenly, maybe there's fewer people working now. Maybe the staffing needs are greater during that time, so there's fewer people who aren't scheduled. But for whatever the reason, a Friday night comes and he's not able to find a replacement. He can't in good conscience skip his religious obligations, so he doesn't show up. When he comes back to work the next day scheduled, his supervisor calls him to his office and says, hey, Bob, you weren't here for your scheduled shift. Bob says, I know that I wasn't. I wish that I hadn't needed to skip it, but I wasn't able to find a replacement, and I couldn't attend because of my religious obligations. Well, the supervisor says, well, that's just not okay. You can't do that again. Please don't. And Bob says, well, I just don't think I'm going to be able to do it consistently. It seems like the people who are willing to shift have all quit or been assigned to other departments, and so I don't think I'll be able to. I'm going to need you to stop scheduling me on Friday nights and Saturdays during the day. And so this is another solution to the problem. The first solution was have the religiously observant employee swap schedules. The second solution could be to have the employer stop scheduling this worker for that time. But then there are other issues that come up with that. Number one, the employer might say, well, if we completely drop this person from the schedule, we might not have enough employees who can meet the schedule. And then there are other issues. Well, these hours might have been premium hours. Bob might have been getting extra pay for working these hours than other hours. If we do that, then Bob is going to receive less pay. Or maybe Bob will receive fewer hours of work if he's restricting the number of hours. So there can be lots of variables in this analysis. And what I want to leave you with is to consider all of these factors when you're trying to reach a decision, and to consult with HR or an attorney to make sure that you're complying, whether you are the religiously observant employee or you're the manager who's making sure that the employer is complying with the law in this area. It's a very tricky area. A concern that often comes up with religious observance in this area is the concern about the copycat. Many people, and this sentence comes up with the majority population in most work units, and in most work units that's going to be a Christian population just because of the demographics of our country. And as a result of that fact, you might have an employee who says, I'm of the Christian religion, my Sabbath is Sunday, it is against my religion to work on that day, and so I want the whole day off. Well, that may be a very sincerely held religious belief, or it could be the case that this person wants a Sunday off for non-religious reasons. Perhaps that's the time that his or her spouse is off, or maybe that's the time that he or she likes to watch the football game or something along those lines. And so if the concern may be, well, if we give that time off to Bob the Christian, well, we might suddenly have Sally and Larry and Teresa all claim that same perspective. After all, they're probably all to varying extents of the Christian faith. And so if Bob gets it off because Bob's a Christian, why can't they claim it off so that they can also have that time off? Well, one of the challenges with this is that it's very difficult for employers to challenge the sincerity of the religious beliefs. Now, it is a requirement that the religious beliefs be sincere, but it's very difficult to prove that an employee isn't sincere. Here are some things you can't consider. You can't say, well, when I hired you, you didn't mention this. Employees not required to share that information at the time of hire. Or you could say, well, you didn't used to mind working on Saturdays. Well, it's okay if the employee has either changed religions or has become more devout. It's also okay if the employee seems to cycle between very devout, not so devout, very devout, not so devout. If the employee is saying, I'm devout right now, the employer can't say, but you weren't before, I don't quite believe you. Now, of course, if it comes to light that the employee is acting inconsistently, for example, let's say the religion requires that the employee refrain from XYZ activity during the Sabbath or whatever the observance is, and the employee does not refrain from XYZ activity, then the employer could say, maybe this is not a sincere belief. But there's even a caveat here, which is that the fact that the employee is not following the letter of the religious perspective is not dispositive. An employee doesn't have to be orthodox, does not have to have orthodox beliefs within that particular point of view. Let me give you an example. Let's say that Bob is a member of a particular Christian denomination. The view of his church is that it's okay for its parishioners to work on Sunday after they have attended church. And the church service is from 10 a.m. until noon. So the employee, can get comfortably to church, say, by 12:30. So any work time from 12:30 on in the day on Sunday is not problematic for members of that congregation. Bob is a member of that congregation, but it is his particular interpretation of Christianity that no work is permitted of any Christian on Sunday. What the employer can't do is can't say, well, you're a member of Church XYZ. Church XYZ stated policy is you can work after 12:30. Therefore, we are going to schedule you to work at 12:30. The employee is entitled to his own individual interpretation of his religion. So this is an overview, again, this very kind of high-level view of what religious discrimination entails. We'll talk more about reasonable accommodation in a couple minutes in a different context. Let's talk about sex discrimination. Sex discrimination has, I guess, kind of three components. One is just generally gender discrimination, when a employer prefers one gender over another in terms of hiring, firing, or terms and conditions of employment. And obviously that is prohibited. The employer cannot prefer women, cannot prefer men. That would be sex discrimination. In the 1970s, Title VII was amended to include pregnancy discrimination. It's the Pregnancy Discrimination Act. It's actually part, though, of Title VII. Obviously, pregnancy is a condition that only women can have, and so when an employer discriminates against someone based upon pregnancy, it is the equivalent, according to this law, of discrimination based upon gender. And the law provides that an employer can't terminate somebody because they are pregnant. That would be unlawful. Well, let me make it a little bit clearer. An employer cannot say, we're going to fire you because you're pregnant, but the employer, they can't say that if the employer allows other people with temporary disabilities not to be terminated. So imagine this scenario. Sally is pregnant. She is about to give birth. Her doctor has said that she needs at least 4 weeks off before she'll be able to safely return to work after giving birth. On the same day that Sally leaves for maternity leave, Bob is in a car accident, and Bob's doctor says that Bob will need 4 weeks off to recover from his injuries. The employer terminates Sally because of her temporary disability that was related to the pregnancy, but allows Bob to continue as an employee. That would be violating Title VII, because you're treating temporary disabilities that are pregnancy-related differently than temporary disabilities that are not. This is also a very technical area. There's lots of ins and outs and things to consider, but that's the general rule about pregnancy discrimination. Going back just to general sex discrimination, let's talk about the Equal Pay Act of 1963. As you can see, this law was actually passed before Title VII, and it doesn't provide as many benefits as Title VII as a general proposition. This is really the first of the federal employment discrimination protection laws that we have. And not surprisingly, when Congress is doing something for the first time, it's kind of maybe taking a little bit of baby steps, so to speak, and that's what we see here. It's not as broad or as expansive a protection as we'll see later with some of these other statutes, Title VII, ADA, ADEA. But what the Equal Pay Act, which is oftentimes called the EPA, provided was that an employer could not pay women at a lower rate for the same work than they were paying men. And similarly, the employer cannot pay men at a lower rate for similar work that's performed by women. And the work has to require equal skill, effort, and responsibility. It must be basically the same type of work. So for example, the work that a second grade teacher performs would be the same type of work that a third grade teacher performs. But it would be a different type of work than what a high school math teacher performs. So there are, where that line is kind of depends. It's a very fact-intensive inquiry. But generally speaking, you're looking at what are the same credentials required? Does it require the same knowledge level, the same skills? And you would certainly say that a high school math teacher needs to have different skills than that second grade teacher. Okay, so we have, then the last category is sexual harassment, which we'll talk about in more detail in a little bit. Okay. Let's talk about national origin. This is still, so far we've only talked about Title VII issues. This oftentimes can be lumped together with race and color. But let's talk about what we mean here when we're talking about national origin. National origin can refer to this particular person's national origin. For example, let's say that my parents were living in France at the time of my birth. Neither one have French ancestry, but the time came for me to be born, and my mother was in France, and so I was born in a French hospital. Shortly after I was born, my parents moved back to the United States, and I've lived the rest of my life in the United States. I don't speak French, I don't know any French people, but I am technically born in France. So that is technically my national origin. Now, it's pretty unlikely I'm ever going to be subject to any kind of discrimination based upon my national origin. For one thing, you would even know about it. But if I were discriminated based upon the fact that I was born in France, that would be a violation of Title VII. That's not the common way national origin plays out. The more likely way it plays out is that I'm from that country, or my ancestors are from that country, and it is fairly clear to other people that I am from that country, either because of my accent, because of my name, because of my religion, or because of my physical appearance. And so those factors can seem pretty similar to race, color, and religion, but they might be also separate. So for example, if my last name is Sanchez, it suggests that my national origin might be Hispanic. Generally, people of Hispanic ancestry, we don't consider that a separate race or color, at least in terms of how we categorize people under Title VII. We would look upon that as national origin. So my surname might be an indication, or it might be my appearance. I might be of Vietnamese ancestry. Perhaps I was adopted by an Anglo family in the United States, so my name is Sally Smith. But when someone sees me, they see somebody who has Vietnamese ancestry. I have the physical characteristics of some of the typical Vietnamese person because both my biological parents were Vietnamese. I would be entitled to national origin protection even if I don't remember Vietnam, don't speak Vietnamese, have no connections to Vietnam other than this biological connection. It might even be the case that I wasn't born in Vietnam. Perhaps my biological parents were living in the United States at the time that I was born, when I was subject to the adoption. But still, because someone can look at me and say, that person is of that particular national origin. It even is the truth that if I am misidentified based upon my national origin, I am still entitled to protection. There's a case, it's kind of a shameful case. I'm a little embarrassed to tell this story because it reflects badly upon us Texans. But after 9/11, there was a gentleman who worked in a car dealership in the Conroe, Texas area. And he was, I believe he was of Indian ancestry, meaning he was from India originally, and that he was of the Hindu religion. His supervisor and his co-workers were not familiar with the ethnic differences, and they assumed that he was a Muslim, not because he told them he was a Muslim, but because they thought that he was probably a Muslim, I guess because he had an olive complexion and dark hair and dark eyes. Anyway, so they very, very badly mistreated him, and he was terminated. And he sued based upon national origin and religious discrimination. And he said, I was badly treated because they thought I was a Middle Eastern person of a Muslim religion. I'm neither. I'm from India and I'm a Hindu, but I was mistreated because of that misapprehension. Well, the employer had the gall to say, well, you're right. We did discriminate against you because we thought you were a Muslim from the Middle East, but since you really weren't, we didn't break the law. If you had really been a Muslim from the Middle East, we agree, we broke the law, but that wasn't who you really were. Of course, the court said, well, that's a ridiculous argument. Not only are y'all bigots, but you're ignorant bigots on top of that, and being ignorant bigot doesn't excuse your bigotry. So you don't. The bigot doesn't have to get your national origin right in order for you to have a claim. So let's talk about another statute. So we've pretty much completed this first statute, Title VII. Now we're going to go on and talk about Age Discrimination Employment Act. And this protects us from discrimination once we have our 40th birthday. So there is no, all these other categories, by the way, are also reverse discrimination. So we're all members of some race, and some of us are members of more than one race. So everyone is protected from race discrimination. You're protected if you're Asian, if you're African American, if you're Caucasian, if you're a Native American, if you're, any race, or if you're biracial or triracial or whatever your racial circumstances might be. Any color you have, anything from very, very fair to very, very dark, you're protected. Any religion you have, you're protected, including no religion at all. Atheists are protected from religious discrimination. Agnostics are protected from religious discrimination. Males are protected from sex discrimination, just like females are protected from sex discrimination. So in all these cases, we have both the main category and the opposite, or the opposite categories. Everybody is protected. And that's been true for national origin too. Every national origin is protected. I happen to have been born in Texas. And so my national origin obviously would be, my ancestors are from European countries, so my national origin would be various and sundry European countries and the United States of America. I'm not too likely to be discriminated against based upon my national origin. But if it were to happen, I could claim national origin protection. Okay, so let's talk about age discrimination. This is the first one that we've talked about that doesn't allow the reverse type of discrimination. This is designed to protect older people from discrimination. But you don't have to be very worldly to know that a category of people that is often discriminated against are people who are discriminated against based upon youth. Oh, you don't know what to do, or you're going to have poor work habits because of your youth, you're going to be irresponsible. All of those stereotypes about the young can negatively impact the ability of a younger person to get employment. But that is not at all unlawful under federal law. This is one of these areas where some states have come in and said, well, we're going to make both types of age discrimination. Age discrimination against older citizens, that's unlawful. Also, age discrimination against younger citizens, that will be unlawful. And because, again, the federal, the Congress has not preempted in this area, they do allow states to provide additional protections. One state who does provide against additional protections, including the young, is the state of Florida. Now, even in states that do prohibit age discrimination based upon youth, they still allow the employer to prefer more experienced people over less experienced people. So let's imagine that a 20-year-old applies for a job. He has no relevant previous, or let's say he has 2 years of relevant previous experience. At the same time, a 35-year-old is applying for the same job. He has no relevant experience. The 20-year-old is the better candidate. The employer can't say, well, we think the 35-year-old will be more responsible, more mature. Yeah, he'll have more to learn about how to actually do the job, but we feel like we can train him and we'll have a better employee. Well, unless you can, in Florida, the state of Florida, unless you can point to something in the interview process that makes you think that this person is more responsible, other than the ages of the two candidates, you can't base a decision on that in the state of Florida. That method of looking at that circumstances, that would be perfectly lawful in most states, including Texas. It's fine for an employer to prefer somebody who is older to somebody who is younger. And again, moreover, an employer would be perfectly within its rights to say to a 39-year-old, we don't want to hire you, you're too old. Wait a second, you're discriminating against me because I'm old? Yeah, they can say, oh, we're not going to hire you because you are 39 and we want to hire young people. Now, if that candidate had actually been 40 at the time of the decision, that would be age discrimination. But discriminating against him because he's old, because he's 39, does not violate the law. So that is age discrimination in employment, ADEA. Now we're going to talk about Americans with Disabilities Act. And so this is the disability protection. We will see that there is that reasonable accommodation requirement that we talked about under religion. So there are two types of protection that isn't just a kind of a negative statement. Don't do this, don't do this, don't do this, but it also has a positive requirement. You have to do at least this. You can always do more, but you have to do at least this. And we see that with religion and disability. But let's first of all consider who is disabled. What does it mean to be disabled? Well, a disabled person is a person who has a significant disability that affects a major life activity. So, for example, I wear glasses. Without my glasses, I would not be able to function very well. I couldn't drive a car. I would have difficulty reading anything other than a book that was close to my face. I would out in the hunter-gatherer society, of 100,000 years ago, I would have been, a nice meal for a lion or jaguar or something like that pretty quickly. But the law wouldn't say that I'm disabled because they specifically exempt ordinary vision differences, and my vision is not so terrible. But let's say that I was born deaf or had become deaf. Well, a major life activity is hearing, and I have a major impairment, so therefore I'd be considered disabled. Other examples of disability would be mobility limitations. Maybe I have to walk with a cane or a walker. Maybe I'm in a wheelchair. Maybe I've experienced an amputation. Maybe another example would be, let's say I'm an insulin-dependent diabetic. That would be a disability. Perhaps I have a learning difference. Maybe I am dyslexic or have another developmental delay. Perhaps I have Down syndrome. Things like that can be considered disabilities. If an employee comes to you and says, I have a disability, and what they tell you doesn't seem to add up to a disability in your mind, my advice would be to talk to somebody in HR or to an attorney before you say, I don't think that's a disability. Because there are things that may not seem like disabilities at first glance that can definitely meet the requirements of the Americans with Disabilities Act. So once a person is determined that they have a disability, they are entitled to all these protections. They can't be their employment cannot be denied to them if they are the best candidate for the job, putting aside their disability. They can't be fired because of their disability, and they can't be discriminated against in terms of the terms and conditions of their employment. Moreover, they can't be segregated. So you can't, for example, have a break room for the wheelchair-bound employees, but have a main break room that maybe has stairs going up to it that the wheelchair user is not able to access. So that's how disability discrimination works. But usually the more interesting area of the law for here is the reasonable accommodation requirement. In the previous one, we were talking about a religion, we use the term reasonable accommodation, and the same exact words are used in the Americans with Disabilities Act. Even though the same words are used, the courts have interpreted this term in a very different way. Under the religion requirements, this reasonable accommodation duty was a very modest legal duty. The employer really could not be expected to spend really any meaningful amount of money to accommodate the religious views of their employee. So shifting schedules when it wasn't costing the employer money or things like that was fine and could be a requirement. But if it was actually going to cost the employer a significant amount of money, courts pretty routinely said, no, that's not a reasonable accommodation. That would be an undue hardship. But under the Americans with Disabilities Act, employers are required to spend a fairly significant amount of money, although certainly the cost of the accommodation can be a factor. So let's say I'm vision impaired, and so I need a larger monitor or a special keyboard for my computer. That's pretty much of a no-brainer. I'm going to be able to get that equipment. Or perhaps I need let's say I'm hearing impaired, I need a special phone set up so that I'll be able to communicate. Again, pretty much of a no-brainer. I'm going to need to be given those tools. Perhaps I'm a wheelchair user and part of my job involves filing. It might be necessary for my employer to rearrange the filing cabinet so that I would be able to access all the drawers. It might mean that the filing area needs to be significantly bigger, or there may need to be ramps so that I can get to certain levels, things along those lines. It might involve reorganizing the work area or expanding the work area or spending money on new equipment or tools or things along those lines. A reasonable accommodation can become so burdensome that it does become an undue hardship even with respect to disability. But before you deny a reasonable accommodation, either in the context of religion or disability, I encourage you to talk to somebody in your HR department or an attorney in your legal department about that. So one of the big surprises that students oftentimes experience in this area of the law is that they are surprised to hear that sexual orientation is not covered. And this really covers any aspect of gender other than the ones we've already talked about. Male, female, sexual harassment, and pregnancy. So for example, If I am a lesbian, I am not entitled to any protection against discrimination based upon me being a lesbian. If I'm a gay man, I'm entitled to no protection based upon my sexual orientation. If I am a bisexual person, not entitled to any protection on that basis. If I'm a cross-dresser, no entitlement to protection for that. If I am a transgendered individual, no protection under those circumstances. None of those present a legal theory. Now, of course, the federal law doesn't encourage discrimination on that basis. It just doesn't prohibit it. And as we said before, there are many states that prohibit those types of protection. That require those types of protections. Texas does not have any of those protections, so it is perfectly lawful in the state of Texas to discriminate based upon sexual orientation or transgender status. Just because that's the law doesn't mean it's a good practice, and there are many Texas-based employers who have policies that prohibit that type of behavior. The textbook, as I think I already shared, makes some incorrect statements about same-sex marriage. Obergefell case makes same-sex marriage the law of the land. Another characteristic that is not protected by federal law is smoking. And there's we're going to talk about smoking, but this actually is a broader category than that. If I am a smoker, an employer is perfectly within its rights to decline to hire me or to fire me based upon that status. Or the employer can charge me a higher, say, insurance premium because the idea is that I will need more health benefits because of my use of tobacco. And really, any out-of-work activity is kind of fair game for an employer to make decisions about. So an employer can prohibit dating within the workplace, can prohibit certain activities such as dangerous activities where the person might be injured. We'll say skydiving, for example, may prohibit activities that might put the employer in a bad light, for example, going to certain clubs that have a bad reputation or something like that. And those would not be violations of the law. Now, one thing employers can't do would be to say, well, you can't date someone of another race. That is considered race discrimination. So let's say that I am a Caucasian and I decide to start dating an African American man. My supervisor comes to me and says, hey, if you continue to date Bob, we're going to fire you. And I say, well, what's your problem with Bob? And my manager says, well, he's African American. And I say, well, Sally is dating an African American man. And the supervisor, you don't have a problem with Sally dating an African American man. And the supervisor goes, well, yeah, but Sally's African American. I don't mind people dating within their race. I don't like people dating outside of their race. You're Caucasian, Bob is of a different race. I don't like it. I'm not going to let you do that. Well, that is considered a type of race discrimination. Some states do prohibit discrimination based upon smoking status and also other limitations upon people's activities outside of work. Generally speaking, you can, but by the geography of where the state is located, pretty much kind of know the states that are likely to have protections. For example, states on the West Coast like Hawaii, California, Oregon, Washington are very likely to have more protections, and states along the northeast coast and some Midwestern states are likely to have, the northern Midwestern states especially, are likely to have protections. This is one area where that doesn't necessarily follow. Some states that prohibit smoking discrimination are states that have historically been very involved in the growing of tobacco products. And so there are states in the southeastern part of the country, states that are generally fairly conservative politically, but because of their economic involvement with tobacco, sometimes do have statutes that prohibit discrimination based upon tobacco usage. But Texas doesn't have any of those laws, and again, there are no federal laws in that category. In addition to not discriminating on the basis of the things we've talked about today, employers also have to put up posters. And here is an example. This is just a portion of the EEOC poster. Goes through and explains all these things that we've talked about here. And you see color, religion, probably has race over here. Race, color, religion, sex, national origin, genetics, retaliation, all of these types of topics. You have to have this poster up, but most employers, at least big employers, choose not to have separate posters for each one of the statutes because you'd have so many posters. So what most large employers do is they use a poster service that will have one big federal poster and one big state poster that will have all of the required information for your particular state. And so that way you only have to keep track of 2 posters. You need to keep these posters up in 2 places. One place where applicants are kind of expected to be, however your business arranges the applicant situation. It might be where the office is, for example. And then also where the employees are likely to be. And this could be where employee lockers are, where the break room is, where the time clock is, those types of places. Sometimes those 2 places are the same place, and if they are, then that's fine, just to have one set of posters. But if you don't want to buy what they call them all-in-one posters, if you don't want to buy the all-in-one posters, then you can keep track of each poster separately. You can actually just go to the website of the governmental agencies and print them up. Obviously, that's basically free. But the challenge there is that you have to remember, oh, wait a second, that law was changed, let me get the new poster. And remember to have all the posters up. So it's a little bit trickier to handle. It's just easier usually to buy the all-in-ones. If you don't have the posters up, what's going to happen? Well, there is the potential for there to be fines for every day the posters aren't up. I'll tell you though, it's pretty rare that people are fined simply because they failed to have the posters up. But it is a piece of evidence that can be used when somebody complains of discrimination. Well, let's say that Bob, we'll say that now he's a Hispanic, and he is alleging national origin discrimination. And he says he was laid off because he is Hispanic. His employer is saying, no, Bob, we laid you off because you were tardy to work 12 times in 3 months. And Bob says, well, yeah, I know that's the reason you gave me, but that's not the real reason. The real reason is I'm Hispanic. So this case goes to trial. One of the pieces of evidence that the Bob can present is that these posters weren't up, even though they were legally required to be up. And so that carelessness on the part of employer shows the employer wasn't very committed to providing a discrimination-free workplace, and perhaps that employer wanted to hide from the employees the rights that they had, because one of the things on the poster is it explains to employees how they can complain or how they can bring violations of the law to the attention of the EEOC. So you can see if you were a discriminator, you really wouldn't want to tell your employees, hey, this is how you file a complaint against us. So that could be one fact that the jury finds meaningful in trying to decide whether the employer was in fact discriminating against Bob or not. So we'll continue on to our next slide when we're next together in the next lecture. Thank you for your attention. If you have any questions about this topic, please email me, come to my office hours, or raise those issues in class. Thanks for your attention. Have a wonderful day.